question is, are we going to see a Gyanvapi moment where Qutub Minar is concerned? Let's take it to our panelists. Joining me this evening, Sanjay Hegde, Senior Advocate, Ashok Kumar Pandey. He's a historian, and very shortly we'll be joined by Aman Sinha, spokesperson, Bharatiya Janata Party. Till now, though, we want to put on record, earlier on there were speculations that the Culture Ministry had ordered an excavation-like survey where Qutub Minar is concerned. The minister in question, Mr. Reddy, has come out and said, till now, yet, and that's the operative word, yet, no excavation survey has been ordered. Will it be ordered? Is it in the offing? Because there is enough amount of noise that is being made on it. Let's take that question directly to the Bharatiya Janata Party spokesperson. Mr. Sinha, appreciate you joining us this evening and to the point. So my first question stems from all that has gone down right now at the Qutub Minar. Is the government at all contemplating an excavation survey? Because till yesterday the word was the Culture Ministry had given a go-ahead. This morning the Culture Minister has come out and said, not yet. Is yet the operative word, or till the court gives an order on it?
Preeti, I believe Culture Minister was very categorical and unequivocal that there is no such direction for excavation, and I think that should put the issue to the rest. However, still you cannot take away from the fact, Preeti, that it's a widely acknowledged historical fact that large number of Hindu temples were demolished, somewhere around 40,000 to 60,000 as the estimates go, by Islamic invaders. And people have right to institute suitable proceedings. In fact, Supreme Court has also said, Preeti, that ascertaining the exact religious character of a particular place is not barred under the Places of Worship Act. And let me also remind you that the constitutional validity of Places of Worship Act 1991 itself is under cloud, it is under challenge, and the Supreme Court is examining the constitutional validity of the Places of Worship Act 1991. So all these matters will be taken up on their own merit, and as of now there are no such orders for any excavation. So I do not think that there is any case for any controversy on this issue, Preeti.
All right, so there's no such order yet, but on the other hand, Mr. Sinha, once you say that, that it is public knowledge, and you're right, it is public knowledge that a lot of our heritage monuments are built possibly on temples. Those temples are possibly built on Jain and Buddha temples. How far are we willing to go on this fight to uncover the truth?
Preeti, as I mentioned to you, that each and every case is going to be examined on its own merits, and everybody is conscious of the legal position, what the Places of Worship Act stipulates and mandates, and therefore we need not get into that controversy and let the courts take a call on that issue. As far as even proceedings in the Gyanvapi matter were also before the district judge in Varanasi today, and they are going to decide the issue whether 711 is to be entertained first or the commissioner's report has to be entertained first. So let us await the court proceedings, how they are going to take place. We cannot prejudge what court is going to do or say, and you cannot even preempt people from asserting their legal rights. It's the Places of Worship Act, Preeti, in fact, the point on which the notices were issued and this was being examined was that it makes a prohibitive bar against people who have been historically wronged for all these historical atrocities, etc. And on that point, Supreme Court is entertaining that issue. So let us see what Supreme Court has to say finally on the constitutional validity of Places of Worship Act.
Right.
But considering this in mind, I think instead of creating controversy over different issues, we should leave it to the courts of law to adjudicate on the matters.
Fair enough. Sanjay Hegde, leave it to the courts of law to, look into the matter on both accounts. Number one, Mr. Hegde, where the Gyanvapi Mosque is concerned, now as per the Supreme Court guidelines, orders, in fact, it's been given to the district court. But isn't the district court now under the orders of the apex court must only look at maintainability of the case and not the commission's report?
That appears to be the intent of the Supreme Court judgment, the Supreme Court order, and in case there is any deviation, there is always the prospect of an appeal to the High Court and then to the Supreme Court. But Preeti, my basic question is, I heard Aman Sinha, my friend, say that let the courts do their work. Is this the work of the courts? Our courts are anyway overburdened. There are so many matters where people are waiting for their freedom. There are so many matters where landlords are waiting for their houses back. There are matters where people want divorces. Courts are meant actually to handle the affairs of the living. Getting into deep history and what happened 500 years ago, 800 years ago, and trying to undo the effects of history are simply not in the realm of the court. That is why we have, in most civilized countries, a law of limitation. Limitation applies everywhere, including in India. And the normal law of limitation is that if for 12 years somebody has occupied any property as the owner and there has been no acknowledgement of anybody's title, he perfects a title by adverse possession. We have a troubled history. Parliament was aware of it. Parliament said, okay, let's draw a cut-off line. And that cut-off line was the day of our independence. Now, Parliament has so far not reworked that act. Parliament has not substituted that act. Why is it that courts are continually being petitioned, saying, oh, that act is there, but you please keep it in the background while we go into everything and that may seemingly be of interest to the petitioners. Courts should be firm. Courts should say, look, there is an act. I have to enforce that act. If you want a change in the act, please go to Parliament.
All right, okay. Aman Sinha, I want to bring you in, and that's a fair point that Mr. Hegde is making. You yourself as a lawyer, are a lawyer. You understand, how the time of the court can be wasted, where people wait years or rather some decades to get their cases solved. Aren't we somewhere down the line wasting the time of the court when we are going to court on issues of the Qutub Minar? Because where does the buck stop tomorrow?
Well, Preeti, I do not believe that courts till this point in time have in any proceeding said that anybody's attempt or intent was to waste the time of the court. Now, we are a democratic country. You cannot prohibit or stop people from even approaching courts of law for asserting their legal rights or for securing justice. That is the basic tenet of any constitutional democracy. Now, as far as the Places of Worship Act is concerned, as Sanjay was also mentioning, and as I mentioned earlier, that constitutional validity itself is under challenge. The sheer fact that whether certain provisions are going to be attracted or not, Section 3 and Section 4, namely, in view of the fact that large number of these monuments are ancient monuments, declared ancient monuments, more than 100 years old ancient monuments. Therefore, they would also get the exemption as enunciated under Section 4 of the Places of Worship Act. And that apart, for instance, in the case of Gyanvapi, Preeti would recall that there is a Gauri Shringar Mandir, which is on that very same wall, and the worship suit was for worshipping that particular deity only. And which is the original religious character of the place? Obviously, everybody knows originally it was a temple. But even on 15th August 1947, whether originally it was Gauri Shringar Mandir wall or what wall, that obviously needs to be ascertained. Supreme Court itself has said that these are matters which require to be ascertained. There is no bar under Places of Worship Act to ascertain the religious character of a particular place. So therefore, I do not feel that there is any wastage of time at all, as it has been alleged. In fact, if that was the case, courts would have said so very categorically.
But, Mr. Sinha, the courts did say so very categorically. The Allahabad High Court, on when your party colleague from the BJP, Mr. Rajneesh Singh, who handles the media cell where Ayodhya is concerned, approached the Allahabad High Court on Taj Mahal to open those 20 gates, was told by the Allahabad High Court that stop wasting our time.
I am not going into each and every case. There was a case, it was decided on its own merits. You cannot, paint the entire picture from one brush. Because, and therefore I mentioned to you, Preeti, that each and every case is going to be examined on its own merit. And we cannot paint everything with one brush and just either dismiss everything or say everything is hunky-dory. That cannot be the approach, and therefore I said right at the outset that let us leave this to the wisdom of our courts, and there are several levels of judicial hierarchy, and there is a robust judiciary that we have in India, and I'm sure they will take appropriate suitable view in all these cases, and I can assure you that, and from my own assessment as a senior advocate, that in all these cases, courts have been taking a very fair and a reasonable view. That is what I can tell you.
All right, Sanjay Hegde, I'll bring you in on this because Mr. Sinha does have a point, because even if we look at what the Supreme Court order was, the Supreme Court could have, if it wanted, shut the entire case down without even putting it across and handing it over to the district court in Varanasi on the basis of the 1991 Act. It did not do so.
Well, the Supreme Court may not have done it for very many reasons, but the primary reason is simply this, that if the Supreme Court takes a decision either way, there is no appeal from the Supreme Court. So therefore, the Supreme Court often, when it is faced at an interim stage with conflicting stands, says that it will not decide things itself, it will send it to the lowest court of first instance, and from then on let the final decision work its way through the courts. For example, you may remember that the Supreme Court was faced with a special investigation team which said that close the case with regard to 2002. The amicus curiae said no, there is something to be looked at in that case. The Supreme Court then sent it, did not take a decision itself. It sent it back to the magistrate so that the magistrate could rule in the first instance. From there, then it went to the High Court, and from the High Court now it's again come to the Supreme Court, which is hearing the appeal. That is the primary reason why the Supreme Court did not, in this instant case, which is still at the interim stage, pass any final ruling. But to assume that just because the Supreme Court did not shut it down, that the lower courts are bound to continue it and continue it for eternity and to keep the communal pot boiling, I don't think that is a right takeaway from the Supreme Court's order recently.
You know, Mr. Sinha, and I'll draw you in on this, because then what we are possibly looking at is opening up a rather sinister Pandora's box, and you would admit, as we speak, Qutub Minar is in court, the Krishna Janmabhoomi is in court, the Bhojshala is in court. In Mangalore right now, there are two mosques which are again, an excavation has been demanded, a survey has been demanded, that's going to be in court. There is the other fallout of it, the vitiating of the atmosphere and possibly trying to wedge wider a communal divide, which has only, become more glaring in the recent past. You had incidents in Neemuch where a dargah, was violated and a Hanuman Murti was installed there. So what are we looking at?
And Preeti, what is also in court is the constitutional validity of Places of Worship Act 1991. This act was passed in a knee-jerk reaction without any consultation, without any such recommendation, any such report of Law Commission of India. The basic tenet of the Places of Worship Act itself, where it bars any remedy and redressal against historical injustices, that itself is under challenge. Why do you not forget that? So, why do you forget that? And therefore, Preeti, to paint and say that people are petitioning the court, therefore it's a communal pot boiling, and if the Places of Worship Act is under challenge, you do not even consider that. On the other hand, when sedition was the constitutional validity was to be examined, entire provision itself was stayed. If going by that logic and premise, if one were to argue that going by same analogy, that should be the status of Places of Worship Act, somebody could have said that. The fact of the matter is that let us not take things too far and too ahead of us. There is a robust judicial system in India, and there are several levels of hierarchy, and people will approach courts. That is what courts are meant for. There is no prohibition under the Act itself, although the constitutional validity is under challenge. There is no prohibition to approach courts of law. The Supreme Court itself stated that there is no prohibition as far as ascertaining the exact religious character of that place is concerned. So let us not, say something which even courts have not said, and try to, give our own, kind of mindsets or vested interests, opinions, etc. So I am not going to get into that. But all that I am saying, Preeti, is that these are all specific matters which are to be dealt by respective courts, and we should have enough trust and confidence in our judiciary to deal with these matters as they have been dealing.
Sanjay Hegde, if that's the argument, then why look at the morality of it? Why look at, in any case, look at what it might lead to or what's happening in society? The fact is, there is a legal recourse available and everything is happening under the purview of the law.
See, firstly, the Act of 1991 has not been stayed. Aman correctly pointed out that the sedition law has been stayed. He should also take the necessary implication that the Act of 1991 has not been stayed. Somebody has challenged it, the court has said, okay, we'll look at it.
I have already said
only a notice has been issued, and the government of the day, which is supposed to defend the Act, I believe has not even filed its reply. Now the second point about people coming to court. Yes, people can come to court for all kinds of things. The question is, do courts entertain them, and how far do they entertain them? And to what purpose do they entertain them? Here, I remember that long ago somebody came to court saying that he had a right to wear a crown while arguing before the Supreme Court. This was in a challenge to a president's election. The case is something called Madanlal Dharti Pakad Kutta. Now the court obviously threw him out, saying that you have no right to wear a crown.
Right.
There can be all kinds of people who come to court. The question is, if a case has to go on, the courts also have to ration their time. The courts have to see, is this case capable of going anywhere? Can you give anybody relief? So here, where you cannot change the ultimate character of the place because of the Act, then why do you go into determining what the character of the place was 500 years ago, 600 years ago, or kingdom come? We've spoken of all these little things of there were temples under it. Under most of Delhi, under most of the poshest areas of Delhi, there are many Muslim graves. Do you want their ancestors also to come and say,
that's what I want to ask. I want to end with that question, and Aman Sinha, I'll bring you in on this, because ultimately, then, where either the two of us, or rather the three of us are sitting, anyone can contest, that there is something lying under. So let's go ahead and have an excavation process.
What is the difficulty? Let the truth come out. If there's anything substantial, if there is any such, substantive thing, why should anyone be scared? Now, I do not understand this logic, people are advising courts how they should conduct themselves and behave themselves. Now, courts are very much capable of rationing their own time. They do not need advice of either Sanjay or my advice or your advice, Preeti. They are very much capable of doing so. And I do not understand this, Preeti, that if there is an act which prohibits any remedy and redressal against historical injustices, if people are approaching courts of law, they are termed as communal. And for all other instances, if people approach courts of law, it is for all hunky-dory objectives of securing justice. You cannot see, our judiciary and all the litigation which is instituted with this colored prism.
Okay, well,
this is against the basic tenets of constitutional democracy.
Okay, gentlemen, ultimately we'll have to leave it for the courts to decide. But on a lighter note, Mr. Sinha, I'd advise you not to give your address or your office address where you're sitting, because, mind you, like I said, if this is how it's going to be, anything can be contested in terms of what really lies beneath.